Grand Indian weddings. Everybody loves them. The food, drinks, and most of all, the Bollywood songs from the golden era and the crazy remixes played by DJs at the Sangeet night and other ceremonies. Now, have you ever wondered about the copyright on those songs? Have you ever wondered whether it's even legal to play these songs without any copyrights over them? I really doubt that you have. And that's completely fine. Leave all that thinking to lawyers like me. IP being one of my major practice areas, I deal with trademark and copyright issues on a regular basis. Copyright law is, in fact, one of my favorite areas of law. I find it to be especially interesting when dealing with cases related to technology companies, media houses, social media platforms, and e commerce platforms. I also deal with a bunch of copyright law issues when I'm drafting contracts for or giving legal advice to creators and artists. So, let me now come to the topic for today's episode. Just a few months back, I was one of the lawyers on a case before the Delhi High Court, wherein the court was dealing with this very issue of copyright on songs for weddings. And this case was filed by an events company, an event management company to be more precise. And the case had been filed against copyright societies. The event management company had said that itself and other event planners were being forced to obtain copyrights for songs being played at weddings, right? They were being forced to obtain these copyrights or licenses for playing the songs from copyright societies. So, what are copyright society? A copyright society is basically a group, an organization, which acquires the copyrights from artists for their songs and then licenses out that copyright to other entities that want to play those songs or want to use those songs, right? And certain hotel groups were also made party to this case on the basis that these copyright societies were exerting pressure on the hotels to make sure that the event planners had obtained such licenses. So I was one of the lawyers representing such a hotel group. Now, the judgment that I'm talking about was given by a single judge of the Delhi High Court on an interim injunction application that was sought by the event planning company. So, for those of you who don't know, an interim injunction is a temporary relief, that is a stay order that was sought by a party that files the case till the time that the case is finally decided. The single judge, in his judgment, rejected the interim relief that was sought by the event planning company. Now, an appeal has been filed against the judgment by the single judge by the events company, which is currently pending now before a two-judge bench of the Delhi High Court. And since that appeal is pending, I will refrain from commenting on the proceedings of the appeal or what is being argued in that appeal hearing. I will only speak about the judgment which was passed by the single judge of the Delhi High Court, right? The judgment in which I was also a counsel. So now you're probably thinking what the whole controversy was about after all, because what is it that is so interesting about this case, right? So why didn't the event management companies simply procure the copyright? That is probably what you're thinking. But there's a good reason that they did not. This is because the Copyright Act under Section 52 provides an exception to any requirement of copyright with respect to songs being played in religious ceremonies. These religious ceremonies include marriage processions and social festivities associated with the marriage, as per Section 52 of the Copyright Act. Now, plain reading of the section would indicate that one can play songs during religious ceremonies and marriage functions even without obtaining a copyright for the song. However, as you already know, nothing is plain and simple for lawyers. There are 100 different interpretations to the provisions of a statute. And the diverse views expressed by lawyers on the same piece of law and the conclusion reached by the judge on the same is what makes these cases so interesting, right? And there were many such interesting arguments made by the lawyers for both sides in this case as well. So, if I were to go into each of the complex arguments made in the case, the episode would last at least 3 hours. So, I don't think that any of you would want to pay attention for 3 hours. So, I would focus on only one or two of the main arguments made and explain them in a simple and lucid manner, as simple as possible. So, the event management company's lawyers argue that the law was plain and clear in its language. They argue that the copyright societies were grossly violating the law by exerting pressure on hotels to compel the event planners to procure licenses or copyrights to play songs during wedding ceremonies and related events. The copyright societies, on the other hand, argue that the law was not as simple as the event planners were making it out to be. They argue that the exception exempting the requirement for copyright only applied to bona fide social and religious ceremonies related to marriage. They argue that in reality, there were several extravaganzas held during marriages which were not of a social or religious nature, right? And they argued that such extravaganzas were large-scale commercial events where top-notch celebrities were invited and DJs minted money. So they argue that these were for profit, were commercial events for profit, which were being held in the garb of marriage ceremonies, and that the law never intended to exempt such commercial events from the requirement of a copyright or license. The event planners and hotels that were on the side of the event planners, on the other hand, argue that even if certain events related to marriage had commercial elements attached to them, the same did not change the fact that there were still social festivities related to marriage and were thus exempted from any copyright requirements. So some of them even argue that the doctrine of fair use of copyright applies where there is commercial usage. So now what is the doctrine of fair use? The doctrine of fair use is a legal principle which allows one to use an artistic work of another without obtaining the copyright if he's doing so for a socially important endeavor. So, these people, they argue, the event planners and the hotels that supported them, they argued that this is actually a case of fair use, that if you're playing songs during weddings, you don't need to obtain a copyright because it is only for a social purpose. And even if there is some commercial element attached to it, the overall social nature and religious nature of the functions exempts them from having to obtain any copyright. Right? They place reliance especially on the plain language of Section 52 of the Copyright Act. So now, after listening to the arguments for both sides, the judge rendered his views. He was of the view that each event had to be seen on a case-to-case basis to decide whether or not it was a social festivity associated with marriage. For example, he said whether a reception ceremony or a 25th marriage anniversary would qualify would depend upon the facts in each case before the court, and an omnibus or general declaration could not be granted by the court. Now, there were other technical grounds on the basis of which the injunction application of the events company was rejected by the single judge also. And I would not go into great detail on this technical, procedural, CPC, Code of Civil Procedure based grounds because the audiences would not necessarily enjoy all that, right? Or be able to appreciate or understand those fine tuned legal technicalities. I've given you a more broader picture of the very interesting side of the law that was argued here by both sides, right? So that was as far as the judgment was concerned by the single judge. Now, the thing is, the law, Section 52, which exempts songs played during marriage and its ceremonies from any copyright requirement, still remains. And its implementation has, in fact, been even further strengthened by a recent notification dated 24th July 2023 by the Department of Promotion of Industrial and Internal Trade of the Ministry of Commerce and Industry. And this notification warns copyright societies to refrain from forcing anyone to get a license or a copyright from them for playing songs during weddings or related ceremonies. It says that if the copyright societies still do so, they would actually face legal action. And the notification serves as a great warning to copyright societies, right? So I hope you enjoyed today's episodes and learned something new from it. Stay tuned for more interesting episodes in my video series. Do subscribe to my channel. If you ever want to understand the law further, discuss things with me, get to know something, you can always reach out to me on my LinkedIn, or you could simply call me up on my mobile number. It's also given on my LinkedIn profile. It's 9654211300, right? And I enjoy spreading this legal education, this legal awareness to everyone. I hope you all enjoy today's episode and stay tuned for more. Thank you.